Friends, welcome to Simzuu. Let's begin our journey with our motto, knowledge prospers all. Let's begin. Today, friends, we are going to see a new definition as to what is an industrial dispute. Earlier, we have seen what is an industry, who is a workman in detail, and perhaps this video, that is the industrial dispute, might consume 2 episodes. What is an industrial dispute? Now, the next category is of terms of employment. So, there is a dispute with respect to the terms of employment, and the terms of employment could be contractual or there could be statutory, governing the employment such as wages. If somebody works, he is to be paid. And if he works, how much? So the hours of work are fixed. Then there are so many other concepts, leave, benefits, or even transfer. So any dispute with respect to this could be termed up as a dispute with respect to terms of employment. Say for example, a demand by the workers for higher wages or dearness allowance. Dearness allowance, as you understand in the vernacular, it is called as Mengai Bhatta, which is a component in your salary. Then there could be a dispute over change in shift timings, day to night. Some big industries work in 3 shifts, or a conflict regarding the transfer policy also. All of these are industrial dispute. And one more thing, there are so many cases also. Say for example, West Bengal government employees, there is a Supreme Court judgment wherein Supreme Court directed the West Bengal government to pay 25% of the dearness allowance arrears to the state government employees, recognizing dearness allowance as a right entitling the employees, and it's not a discretionary charity, is what Supreme Court said. Okay, then there was another case, Tamil Nadu Electricity Board versus state government. State governments, according to this case, are not bound to match the dearness allowance with that of the central government. Now you see, central government gives the dearness allowance, and the state governments feel that after some days they are also going to get the same quantum of dearness allowance. Not necessary. I mean, that cannot be a right as per this judgment. Then change over shift timings. It so happened in Hindustan Shipyard versus workmen of Hindustan Shipyard versus Industrial Tribunal, wherein change in the working hours affected the conditions of service. And this case squarely came under section 9A of the Industrial Disputes Act, read with the 4th schedule. And 9A pertains to notice of change, and for which it was held that yes, it is an industrial dispute. Basically, we later come to 9A, first what it is, and it is ultimately an industrial dispute. And the next is, say for example, Food Corporation of India case. It's a Bombay High Court case wherein the company, what it did is, it changed the shift timings. So some people never got overtime at any point of time, and then ultimately said that this is discriminatory. And when you change the shift timing, you have to give a notice, which is a notice of change. But what it is an industrial dispute. Or we also spoke of transfer. Transfer is an incident of service. When a person or an employee is transferred from A point to B point, or from this city to that city, of course, we have to see the appointment letter first, whether there is a clause of transfer. And an employee, of course, he cannot say that I will not get transferred if at all that clause is present, because transfer is an incident of service. According to the Supreme Court, with every transfer there is some inconvenience which is bound to be there. People in India are very funny. If you say your office is at 2 kilometers, people think, why not 1 kilometer? If it is at 1 kilometer, why not in front of my house? And if it is in front of your house, then people think, why not next to my house? So all of these things and expectations go on. The place or a post cannot be a choice of the employee, is what the Honorable Supreme Court has held in a number of cases. But ultimately, coming down, friends, what am I talking? What I am trying to convey to you is, all these are industrial disputes because they fit within the definition of section 2K of the Industrial Disputes Act 1947. Now the next point in the definition is conditions of labor. Employment, non-employment, terms of employment and conditions of labor of any person. Any person we see later. What is conditions of labor? Now this refers to the working environment and facilities provided for employees, welfare, safety, health and all of that. For example, say a demand for a better canteen. Statutory canteen provision we know in the Factories Act, but in those cases when there is no canteen only. So there could be a demand for a better canteen, better restrooms, crash facilities, medical facilities. They are all conditions of labor. I remember a neighbor of mine once asked me to appear on behalf of his nephew. And what had happened is his nephew, by way of a punishment, the manager in that industry, what he did was, this nephew was asked to sit behind the exhaust. The exhaust, you know, it will suck up the hot air from the room and throw it outside. So here the air comes up and it's thrown outside. There is a concavity, like a cone, the air is thrown out. He was made to sit behind the exhaust with all the hot air coming on his face. This was treated as an inhuman condition of service and was struck down by the Honorable Industrial Court. Then there are disputes over, say, unsafe machinery, working condition, fencing. So many of the provisions we can see in the Factories Act also. Then there could be a complaint about denial of weekly holidays or excessive working hours. Now what am I talking? This is all industrial dispute. I mean, it fits squarely covers under one word only, that is an industrial dispute. Say a demand for a better canteen or for a better restroom or medical facilities. In Indian Oil Corporation versus Workmen, it was held that the provision of a canteen and amenities were held to be valid subjects of an industrial dispute. You cannot turn an Nelson's eye to all of these facets of work, is what is held by the Honorable Supreme Court. And then dispute over unsafe machinery or working conditions. What would happen to the workers? Because the machines, some are heavy machines, some are hazardous processes. And in Glaxo Laboratories versus Presiding Officer Labour Court, it was held that the safety and health measures fall within the conditions of labor and are subject to adjudication. Now friends, we also see complaints about denial of weekly holidays or excessive working hours. A weekly off is, well, to be given to every worker. Everybody enjoys a weekly holiday. Of course, it was started by Narayan Meghaji Lokhande, we know all of that. And excessive working hours. How many hours you have to work? Or you make a person work hours and hours and hours together, just forgetting 8 hours and 9 hours and 10 hours and overtime and everything, just make him work. Can you do it? Answer is a simple no. And weekly hours, hours of work, rest intervals are integral conditions of service conditions of service, and hence they are all industrial dispute. Any dispute pertaining to weekly holidays, excessive hours, working conditions, unsafe machinery, canteens, this, that, restrooms, crash, everything is an industrial. And friends, then the last part of the definition. A dispute or a difference between employers and employers, workmen and workmen, employers and workmen with respect to employment, non-employment, terms of employment and conditions of labor of any person. Now the point is, who is this any person? Is it some individual? Answer is a simple no. And this any person, it was held by the Honorable Supreme Court in Workmen of Dimaguchi Tea Estate versus the management. The Supreme Court explained the scope of this word any person, and they held that any person means a dispute, if at all it affects the workmen as a class and not merely an individual grievance, unless it is espoused by a union or a group of workers. Any person is, sometimes a company is also a juristic person. So the any person is taken in that sense. Okay. So this was well enshrined in Dimaguchi Tea Estate. And now we have to see, a big question arose. Definition, see, at the cost of repetition, I repeated it 2 or 3 times, and it so happened that I was a worker. Listen carefully. And it so happened that there was some recognition thing going on in my industry. So a union in my industry came to me and said, come on, give us the subscription. It is hardly 2 rupees. And I told them, no, my family members have told me, main bola, mera kaam bola, I don't want to be a member of your union. Next day, the B union came to me. And again they said, come on, be a member of our union. If workers don't unite, how could there be a unity? And I said, no. My family members tell me, main bola, mera kaam bola, I cannot be a member of your union. Same happened with Union C. Same happened with Union D. And then after some time, some days, the management, one day they called me. And the manager, you know, there are whimsical managers also. He told me that I don't like your face. Come on, get out. You are terminated. I begged and begged, but ultimately he was not to listen. On the face of it, it is an outright termination, totally illegal. So what do I do? Then I thought that maybe somebody should help me. So what I did is, I went to these unions. I went to a union. I said, come on, help me. The union guys looked at me and said, are you the same person we told you to be a member of our union? And you said, main bola, mera kaam bola. Come on, get out. They did not make me stand even in their office. Then I went to B union, again the same thing, that I have been terminated. It's an illegal termination. And the B union guys also told me, that's what we were telling you, workers should unite. And what did you tell us? You started giving us big sermons. And what was the sermon? That main bola, mera kaam bola, and your family members have told you this and that and what not. Just get out. So there was nobody on my behalf to espouse my cause. So ultimately I thought of going to the court, and then I got a shock of my life. That section 2K of the Industrial Disputes Act spelt what? That's why I repeated the definition so many times. It's a dispute or a difference between employers and employers, which is plural. Workmen and workmen, it is plural. And here I am an individual. So the question which arose was, can an individual dispute be called as an industrial dispute? And the answer was a simple no, because the definition did not allow. So what do you do in India? Well, this was sensed by Government of India. And let me tell you one more thing, which as students of labor law, whether you are a personnel manager or an HR manager or a director or anybody, be it, or a lawyer, we are all students ultimately. The moral of the story is, or the message which I will give you, the mantra which I will give you, remember this incantation for the rest of your life, that jiska koi nahi hota uska खुदा नहीं, खुदा comes later. जिसका कोई नहीं होता, उसका Government of India होता है. And this is what exactly Government of India did. They amended the definition. And after the amendment, the Industrial Disputes Act, the Industrial Dispute read it this way, that any worker or any workman who is retrenched, who is discharged, who is dismissed, or who is retrenched because of an industrial dispute, his dispute, though not espoused and though not supported by a union or a group of workers, yet it will be an industrial dispute. And there have been so many cases also to that effect. So friends, you will see a marked difference between the cases earlier to 1965 and the cases later to 1965. Express newspapers versus the management, which is an after 1965 case, wherein individual workmen have filed cases against mighty managements. Or you see Binni versus management, or you have to see all 1965 is a benchmark. After that, all the cases are pro or post 1965 cases, wherein today if you see, the labor or the industrial courts are flooded with cases which are individual disputes because of the 1965 definition with respect to, say, a person or a workman, to be more particular, who is discharged, dismissed, retrenched in consequence of all of these things. So friends, the marked difference which I was talking of is post 1965 and earlier to 1965. But today we are not much concerned about the earlier to 1965 period, because today individual disputes are industrial disputes with respect to dismissal, discharge, termination, and in some state acts, say for example the MRTO and Pulp Act in state of Maharashtra, the 1971 Unfair Labour Practices Act, wherein individual workers can also challenge transfers, modified transfers, so on and so forth. This amendment of 1965 introduced section 2A to the Industrial Disputes Act, and many a times we see the working class, but they are also now well educated. They say yes, 2A ka reference ho gaya. So 2A reference means this 2A, which is the amended section which was introduced into the Industrial Disputes Act by the Amendment Act of 1965. So friends, taking a conspectus of everything, the definition remains as to what is an industrial dispute in section 2K of the Industrial Disputes Act. And we have seen 2 episodes of this definition. We at Simzuu wanted 3 definitions to be very we were very particular about 3 definitions. One is what is an industry, who is a workman, we had 3 episodes, and what is an industrial dispute, 2 episodes. So in our journey of knowledge prospers all, we will meet you next time with something else. Okay, thank you so much.